The following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori? Good evening, everybody. Welcome to Viewers Discretion. I'm your host, Joe Neerman, aka Good Lawgic. I got Lady Lawgic, like, this is tight. This is too tight. Too tight. Too tight. No, too loose. Too loose. That's what she said. Trying to go to sleep and like 6 feet away from me, having a zero chance. Yeah, zero chance. And tomorrow, in case you missed it, tomorrow we're gonna be walking our daughter down the aisle to her wedding. So she needs her beauty rest. And still I'm here with you fine people. With you. It's not choosing them. It's not choosing them. This is timely stuff. I need to cover this. I can't. This is like Fani Willis. How am I supposed to not? I wanted to have the lamp. We gave the lamp away. You see, the normal glow light I would have here on a Saturday night, the normal glow light that like is like, ooh, Joe's like in his glow zone. That, which no jokes about that. That is that's not here. That's not here. That was given to, I don't know, it was seated away to one of my kids because they needed the light. So now I have my big overhead light, which I almost never have on a Saturday night. Anyhow, that's not your concern. That's not your concern. What your concern is, what's happening with Fani Willis? What is happening with her? What's the story? She put in a response too. That's right. She put in a response, and we're going to go through her response because she has all these wonderful explanations as to why it is that the judge should not be remotely concerned about all this evidence, which makes it look like she and her boyfriend, that her little boy toy and her got up on the stand and swore under oath stuff that was seemingly complete and total lies. Don't look at that, Judge. You know, that's really very boring stuff. Very boring stuff. It's very boring. I don't know why are you covering this. It's so boring. It's such boring stuff. Am I right? Am I right? I mean, it's me, right? It's him. It's me. Is it me? It's him, right? It's him. It's very boring. Very boring stuff. Oh, it must suck to be Nathan Wade. Well, thank you for all the nice mazel tovs. That's so sweet. Start Rumble. It's still looping. Why is it still looping? That shouldn't be looping. I did start Rumble. What the heck is happening there? It looks like it's playing. Yeah, that's not on the right. What the hell is happening? What's happening? Is Rumble still not working? Rumble's working fine. I don't know what y'all talking about. Gosh, all these people complaining. All right, Rumble's fine. Everyone's saying there. RPP saying it's fine. Everyone's saying it's fine. All right. Can we get down to brass tacks? I got stuff to do. I have really deep humanities to get to. I've got supplemental pleadings, supplemental exhibits, not pleading, supplemental exhibits. I've got responses to these supplemental exhibits that were frantically fired by the district attorney's office saying, no, don't look over there. Don't look over. Why are you looking there? Why are you looking at that? That's crazy to look at. But before I get to any of that, I should weigh in on this here. In case you missed it, which you may have, because I didn't call it to your attention. I didn't say anything about this until now. But Governor Nikki Haley, former South Carolina Governor Nikki Haley, got to enjoy what is likely her strongest showing in the primaries, where she managed to come in second. She came in second to Donald Trump in the great state of South Carolina, in her home state of South Carolina, where she served as governor, and they really liked her. They really was like, wow. They were like, yeah, she did a pretty good job there. She came in second. which I'm sure in her victory speech that she must have given afterwards, Lord only knows what the hell she would have said other than like, yay, we won again. All the doubters question whether or not we can cross the 25% threshold. Well, we're still here. Oh my, 425,000 votes to 277, which is 3 out of 5 if you do the math. More than 3 out of 5. Yeah, so there you go. Donald Trump waltzing his way into South Carolina and basically say, shove it, Nikki. You're done. Speaking of done, don't worry, Lady Lawgic gave up. She's like, I'm out. I'm out. So yeah, poor Haley, poor Nikki Haley, finishing last in a 2-man race. I mean, I guess Ron DeSantis technically got 0.4%. Oh my God, poor Nikki Haley. Oh, I can't see enough terrible things happening to her campaign. I want her campaign to just be set on fire. Set on fire. Liar, liar, your pants. Yeah. So I think that we may be seeing the end of Nikki Haley. I think we're getting close. I think this trouncing, I don't know if she's going to make it to Super Tuesday. I don't know if she's going to make it to Super Tuesday. Maybe. Who knows? Who knows? Could happen. It's only 10 days away, Super Tuesday. I don't know if she's going to make it there. I don't know. She's the energized bunny. She just will not quit. We're going till we win the White House. Crazy lady. She's insane. So good job, South Carolina, and telling Nikki that no, you don't want her. You don't want her. You don't care if she was your governor there before. You don't care. Nope. Thank God. Even South Carolina is like, no, we don't. This is not our bitch. Not a girl. Not our girl. Anyhow, with that being said, let's turn our attention now. We can pop the champagne on that. Because I'm doing a lot of champagne. I'm telling you, I came in here so buzzed tonight, and like I had to like be tempering it down because like, you know, she's trying to sleep next to me, and I was so buzzed. I was like, oh, ready. Well, I'll show you what I was playing. Sometimes when something comes into my shorts, not that, you know, my shorts feed. Something comes into my shorts, and I'm just like, oh man. I just get the jive. I guess I start jiving, and this is what I was jiving to.
Whoa, Black Betty, bam lamb. Whoa, Black Betty, bam lamb. Black Betty had a child, bam lamb. The damn thing gone wild, bam lamb. Oh, Black Betty,
what?
Bam lamb. Oh, Black Betty,
what?
Bam lamb. Black Betty had a baby, bam lamb.
Oh Lord, Black Betty, bam lamb. Oh Lordy, Black Betty, bam lamb.
Who knew? Who knew that was a cover? Who knew that was a cover? That's right. The day that my daughter's walking down the aisle, I'm jamming the Black Betty. All right. Well, anyhow, I digress. You don't care about that. You care about this. This is what you care about. I'm going to give the people what they want. I'm going to give the people. This is so wrong. Oh, so wrong. So wrong. No. I have the best music. Please stop it. All right. There we go. State of Georgia versus Donald Trump, Supplemental Defense Exhibit 38. You probably have seen people talk about this. I'm not going to kid you. You probably have. But you haven't seen me talk about it. And I have the response, which few people have had a chance to cover yet. And I'm looking forward to going through their response. There was the Fani Willis response. We will get through that. But before we get to the response, first we need to know exactly what Fani's responding to. So we're going to make sure we cover that. Little Miss says, my father told me I got hitched in my 55 years of marriage. Divorce never crossed my mind. Murder, but divorce never. Yeah, my brother-in-law has a joke that goes like that. Like where it was a guy celebrating his 25th anniversary. And like his kids find him like crying. And they're like, "Why, Dad? Why are you crying? I don't understand. Why are you crying, Dad? I don't get it. Why are you crying?" He's like, "The day I got married, I knew it was a mistake." So like, okay. He's like, "I wanted to kill her. I got home and I wanted to kill her." And I said, "I can't kill her. I'm gonna give me 25 years." So like, so why are you crying? He's like, "I would be free." And Jews refuse favors on the daughter's wedding. Also, Fanny's response is better. Her response is better. Her response is better than previous. It's better than her motion. It's better than the Willis. It's better than Wade's motion. That's for sure. Wade's motion was terrible, terrible, terrible. Wade's motion to keep them out of having an in-camera meeting with Terrence Bradley was terrible. Her opposition to this motion, to this, her application, her motion to dismiss and disqualify, her motion to basically tell the judge, don't listen, don't look over here, is funny, but it is, from a legal perspective, certainly stronger than Wade's motion to say no in camera, don't talk to Terrence Bradley. So they may be successful. We'll get to her response. But let's see what it is that she wants to keep out so badly. Let's see what it is she wants to keep out. President Trump hereby files this proposed supplemental defense exhibit 38 to the hearing on defense motion to dismiss and disqualify. Proposed supplemental defense exhibit 38, which means it has to be accepted by the court. Court does not need to accept it. It's proposed. They're saying, please accept this. And we're going to see Fanny's response saying, no, you cannot accept it. Consists of an affidavit from defense investigator Charles Mittelstadt certifying cell hawk analysis and reports which are attached to the affidavits exhibit A through C, cell hawk analysis reports, as well as certified AT&T records. So, let's move along. What do you got here? Here's your little certificate of service saying, I hereby certify I electronically file a foregoing document with the clerk of the court using Odyssey eFile George electronic filing system. We'll send notification of such filing to all parties of record, meaning everyone has an idea what's happening on. Signed off by Steve Sido. And this is the affidavit of Charles Mittelstadt. Dag. Still too small, too big. Lead attorney, local. He's a good attorney. He's not bad. Definitely not bad at all. He's a smart guy. I'm to like lead attorney a lot. Affidavit Charles Mittelstadt. My name is Charles Mittelstadt. I'm 59 years of age, 59 years young. I'm a criminal defense investigator working with attorney Steve Sido, Jennifer Little in support of defense of Donald J. Trump, which means I'm based in this case here, 23 SC 188947, in conjunction with counsel record from Michael Roman on or about February 9, 2024. I personally served a request for records upon AT&T Subpoena Compliance Center. Now, this is an issue here we should take note of. They didn't make the request until February 9, 2024. Perhaps, arguably, they could have made this request a little bit earlier, which would have helped its admissibility, because we're going to see that the timing here is it's a little bit late to be bringing this in. And the fact that they waited, they filed this motion, I believe, in early January, and they didn't start searching for phone records until February 9th. That could be a bit of an issue. I personally served request for records upon AT&T Subpoena Compliance Center. Request documents include voice, call, text history, as well as specialized location data for AT&T number blank 5822. Please don't call Nathan Wade at that number. On the morning of February 15, 2024, counsel received this response from AT&T containing an encrypted link to the requested records, and I was provided access to the zip file containing the response. See, this was on February 15th on the morning. That's the day that Nathan Wade was taking the stand. That's the day. Following my review of the zip file, I confirmed that AT&T fully complied with the request, the bulk of which included records of the period of 1/1/2021 through 11/30/2021. So now they didn't start their relationship, according to their testimony in the affidavit of Nathan Wade, until March or April of 2022, which would be 3 to 4 or 5 months after November 30th, 2021. Certified records are from AT&T are included in the clouded folder titled Records, which is being contemporaneously served upon all parties so they can look at it themselves. Upon receipt, I began analysis using a leads-only analytics tool called CellHawk. CellHawk is considered by law enforcement to be the gold standard in cell phone records analytics. It is used throughout the United States and Georgia by law enforcement agencies and should be well known to the Fulton County District Attorney's Office. They almost certainly have used it themselves from time to time. As a board-certified criminal defense investigator, having specialized in criminal cases for over 25 years, I routinely use CellHawk to conduct analysis records, both on initiated subpoenas and those received in discovery. My firm was granted a license and completed training in 2019. I pay an annual licensing fee, and CellHawk is the program I use exclusively to analyze such records. So CellHawk is fairly reliable. Since that time, my staff and I continuously attend webinars. We remain up to date on training and the latest features available via CellHawk Analytics, so I know what I'm doing when I'm using CellHawk. I have a strong working knowledge of its capabilities and limits, and I have extensive experience utilizing this program to analyze cell phone data. While I'm not a cell phone tower engineer expert, I have the equivalent expertise and training of those individuals routinely tasked by law enforcement agencies and the district attorney's office with identical analysis responsibilities. So whoever you're going to send in there, they probably don't know very much more than I do about this. A cornerstone of the CellHawk Analytics tool is the inability to manipulate the data. That's why people probably trust it, because if you can't manipulate the data, that makes it more reliable that it's actual data rather than something that an interested party might sort of play around with. Data is uploaded as received by the cell provider custodian. Once loaded, it can be queried and examined in innumerable ways. From there, data reports can be generated using filters, geolocation data, and can be displayed in unlimited ways, including via an animated map. That's what I want to see. I want to see a map showing Nathan Wade, zooming over from his house to Fani's house, a big smile on his face there as he's like, I'm heading on over to Fani. It's 12:30 in the morning, and I'm driving on up for Fani. That would be. I mean, someone's got to make that. Someone's got to make that. That has to happen. That has to happen. I demand the people. No, not I. I'm insignificant. The people demand it. The people demand it. The animated map. That's it. One of you has enough talent to make this happen. The animated the CellHawk animated map showing Nathan Wade driving at 12:30 in the morning to Fani Willis's house. Big smile, maybe put him in a smoking jacket. I don't know. You can use your own discretion here. I used my own discretion when I made my thumbnail. Those are not, I don't want to mislead anyone here. I'm certainly not looking to ever mislead anyone in facts. Those texts that I put up there, I put their faces in there, okay? If you're looking at the thumbnail that I created, I put those faces in. That was not an actual text conversation between them. It was simply what I imagined being a typical 12,000 freaking messages. We'll get there. We're going to get there. 12,000 in 1 year that they were supposedly not romantically involved. 12,000. Oh my God, how does he have patience for the constant buzzing of his phone? She's like, you miss me? Do you still miss me? Do you still miss me? Do you still miss me? Oh my God. Oh my God. What that guy won't do for money. You still miss me? You still? I'm picturing like the Simpsons, are we there yet kind of thing. You still miss me? Yes, very much. Still thinking about you. As I'm reading your last text message, when your question of am I still thinking about you popped in here. Oh my God. All right. I need an animated map. Someone please, for the love of God, make it happen. Make it happen. I'll consider it a wedding gift. I will. I'll be like, oh, you see, that's nice. That's people who care. Under normal circumstances, analysis is conducted on data involving far narrower record periods, perhaps a few days or even a few weeks. It's difficult to understate the amount of data in this scenario, however. While the sheer size in no way impacts the ability to conduct the analysis, it did require a different approach in order to narrow down potential dates to explore. I began my analysis by focusing on two distinct reports. Number one, generating report attaches Exhibit A, isolating all interactions. This includes voice calls, text messages between Mr. Wade and Ms. Willis during the period of available records in 2021. The dates, timing, frequency, duration of these interactions are included as part of the report. The report revealed over 2,000 voice calls. 2,000 voice calls. And just under 12,000 text messages exchanged over an 11-month period in 2021. There you go. 2,000 voice calls, 12,000 over the course of a year. I ran the numbers on Friday. Over the course of a year, that would be 5+ calls every day. Oh, you missed a day? You got to make 10 calls today. And 30 text messages. I don't even know how you have time if you're on the phone that much to get any work done, much less that why are you sending text message? You're on the freaking phone. Like, did they spend any time apart from each other in 2021? That's what I want to know. How much time are you not engaging each other during your very, very non-romantic relationship? I just want to know. I just want to know. A heat map, which fortunately does not show their physical bodies, attached as Exhibit B, highlights the interaction patterns which demonstrate prevalence of calls made in the evening hours. Let's check out Exhibit B while we're here. He wants us to look at Exhibit B. Let's go check out our little heat map. I want to see a heat map. Oh, I don't have the heat map. Dang. I think it's in the next thing. It's in the Fani response. It's in Fani's response. Should we check out the heat map? Let's go down. Check out the heat map. Here we go. Heat map analysis report. A little blurry there, I understand, which we will consider that, like, in order not to be too humiliating. You're seeing a heavy concentration after hours 7 days a week. Uh-oh. 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 Well, probably because they're busy, a little bit working during the day, during regular business hours. So they got a lot of them after hours, approximately 12,000, with heavy concentration after hours, 7 days a week. These are like high school kids. They're like high school kids. That's what they are. They're like high school kids. All right. I guess them hormones are raging. When the hormones are raging, don't come a paging. Focusing on a geolocation activity near 3300 Dogwood Drive, Hapeville, Georgia, which was testified by Ms. Yurdi as address of her condominium. Did she testify that out loud? Did they say that out loud? Are we supposed to know this? No one go there. I mean that seriously. No one harass anyone. Please, don't. I mean that 100% serious. And generating a report to reflect such activity attaches Exhibit C, given the urgency associated with the need to analyze this newly acquired data against the relevant testimony. I constructed a very conservative geofence which has isolated the two cell towers in closest proximity to the address, one roughly 3,000 feet and the other 2,000 feet away. Really not, that doesn't seem to be that far. It's within half a mile, right? I mean, 3,000 feet is 3/5 of a mile. Half to 3/5 a mile. The purpose of this geofence was to conduct an initial assessment of whether Mr. Waite's phone ever connected to these towers. Additionally, this modality was used to eliminate the possibility that HIPs could be associated with routine travel on either I-75, I-85, or visits to nearby attractions or the airport. Like maybe he was at the Porsche Experience, like he testified. Now, I should point out, these are the hours of operation for the Porsche Experience. Don't think I didn't come prepared. I did. I came prepared. In case you're wondering, maybe the Porsche Experience has stuff at 12:30 in the morning. No. Apparently, if you want to book a reservation of the Porsche Experience in Atlanta, you got to show up either between 9 a.m. and 1 p.m. or between 1 p.m. and 5 p.m. But the whole 12 a.m. viewing at the Porsche Experience that he says he sometimes goes to, not so much. No. And there is a little bit, what I like about this is there's a little bit of an explanation as to why this is so late. In other words, the point that they're making here is that this is for purposes of impeachment. So they sort of want to be able to analyze and focus on periods of time based on what they are testifying to. You can't just examine 6 months at a time. There's way too much information to examine. So that's why they want to sort of zero in based on what the testimony is. And that could explain why it is that they waited as long as they did, saying we couldn't even start analyzing this until he took the stand. So this is, we're working on short notice here. And the fact that we didn't make a request till February 9th doesn't really matter. The point being, we had it available to us February 15th. As soon as he takes a stand, we know what's happening there. So I expect that will be the reply that we can anticipate from Steve Sado. He's a very smart attorney. Trump's attorney has proven to be, when he walks in the room there, so far, whenever we've seen him, he has come across to me is at least as sharp as any other attorney in the room, and arguably far sharper than most. So that should give you some confidence. And he's the one who crafted this affidavit on behalf of Mr. What's his name? Middleton? I don't want to get his name wrong. Middlestat, Charles Middlestat. So, and you saw what you can see. We're going to see a little bit how Charles set him up, how Steve Sadow set him up. He knew this was coming. He asked about phone records when he had Nathan Wade sitting there on the stand. And we're going to look at that a little bit. Following the initial conservative sweep limited to those two towers, I further constrained those findings to hits on Alpha Sector, or Azimuth 2, which pointed directly at the Dogwood Drive community. Additionally, the report was limited to those occasions when the phone was connected for an extended period. So if he happened to be driving past Fani's house, we kind of weeding those out. We don't care about that. I care about like when he's stationary. Or at least his phone is stationary. He may not be stationary, but his phone is relatively stationary. The conservative analysis using the above reference modality revealed a minimum of 35 occasions. 35. They said 10. Roughly 10 times? 35. 35. 10 is not close to 35. When you're trying to ballpark something, you say roughly, and you come in around 10, and they both happen to come in around 10. And it's actually conservatively 3 dozen. No. 35 occasions when Mr. Wade's phone connected for extended period to either of those towers in close proximity to Dogwood address based on the associated data used, voice calls or text messages. Data reveals he's stationary and not in transit. He's parked right by your house. Deeper analysis of the data would reveal additional data such as where his travel began or ended. For purposes of my analysis, I determined that his residence is located in East Cobb and was able to review the records which demonstrate his phone pinging off the associated towers near his residence for consistent periods. Because of limitations in analyzing the sheer volume of data and preparing the report, I was directed to conduct a deeper analysis on 2 specific dates. So all he really focused on was 2 dates. Could be a lot more dates. There's 35 occasions that he's there, but he focused on 2 of them. One was September 11th to 12th, 2021, before I understand Mr. Wade was hired, and November 20th to 29th to 30th, 2021, prior to what I understand was the in-court testimony that the romantic relationship began in 2022. Specifically, on September 11, 2021, Wade's phone left the Doraville area, arrived within the geofence located at the Dogwood address at 10:45 p.m. So here we're tracking Wade's movements. So he basically gets to the vicinity of her house at 10:45 p.m. Phone remained there until September 12th at 3:28 a.m. At which time the phone traveled directly to the towers across located East Cobb, consistent with his routine pinging in his residence in that area. So we got a period there of 4 hours, 5 hours, I don't know. A long time, nearly. If it was 10:38 p.m., so that would be exactly 5 hours. So it's basically, it's nearly 5 hours that he's there until 3:30 in the morning. The phone arrived at East Cobb approximately 4:05, and records demonstrate he sent a text at 4:20. You know what that text was? Don't worry, honey, I'm home. That's what it is. Why are you texting the DA at 4:20 in the morning? I'm home. That's what the text is. That's what that's what that is. Everyone knows that's what it is. Everyone knows what's happening here. And it's hilarious to me that there's no, you don't know, nobody, I don't know, maybe, I mean, you don't have proof, there's no proof. It's not like we're looking for a conviction here. You got to show the appearance of impropriety. I mean, I think we fairly established the appearance of impropriety. To me, it seems definitely at least an appearance. Someone can reasonably conclude that something salacious is happening at least on September 12th. More than a month and a half before he's hired to get the job. And that they kind of swore that nothing was going on. Nothing's going on. Why do people think there's nothing happening here? Nothing's going on. joke. What an utter joke. Well, let me get to some of these here. Let me pause and get some of your comments so you don't feel like I'm leaving you out in the blue here. Worcestershire. About time, Mr. Joe and Lady and hi, Lady Lawgic. Miles tell parents of the bride, Lady Lawgic doesn't need beauty sleep. She's stunning always. There you go. Allegan News says this is Trump's lawyer. They did not sign onto motion right away, explaining the delay. Okay, but still, they waited till like a week before the week before they're supposed to go into the hearing here. They waited. Check PayPal sent your baby some money to make up for being only girl in the house now. Oh, you're so sweet. Thank you. Let me do that right now. Let me check that out. People send me stuff. You're so kind. Oh, I got you. Nothing works on my computer. I try logging in. They never want to let me in from my computer. Let me see what we got. Oh, it's not showing yet. Let me check this one. Do PayPal. I'm checking PayPal. I'm not seeing it. I appreciate all the same. But I am not yet. Maybe I'm missing something here. I don't know. Maybe it just hasn't come in yet. That's probably what it is. It probably just hasn't come in yet. No, thank you. Thank you so very much. It's very, very thoughtful. Not necessary, but very, very thoughtful. Thank you. Divorce finance disclosure had $2,000 in the bank. Hungry. Yeah, he's very hungry. He's very, very hungry. This is just Tower Data. Fannie's response is daring them to search actual phone. Anyone remember Murdoch trial and step movements? Yeah, I do. And I remember those step movements actually, to me, exonerated him because it didn't make any sense. But I really must know, did you get the good cheesecake? It's funny you asked that, Debbie, because that topic came up tonight. That came up in the Lawgic house, the topic of getting cheesecake. And Lady Lawgic pretty much caved and said, fine, get your cheesecake. You order it. So I haven't gotten it yet. It's supposed to come for next Saturday or next Friday. And yeah, so that's going to be, I do plan on getting that. Ian, what was that? You're going to get it and you're going to eat it too. I'll have my cake and eat it too. There you go. Each of the visits is about the same length of time that you should consult a doctor or something less long. Democrats really are blue-pilled. Nice. I like how you did that. Well done. I don't know. Look, it was very impressive. 4 hours. There you go. That's pretty funny. Well done. All right, let's get back to work here. I'm working. I'm busy working. Y'all trying to strap me with funny stuff. Oh my. Mini Taka. God bless you. Oh, this is not working. Hold on a second. I gotta fix one thing here. Give me one more second. I gotta just remedy this. Let me just go in here and my Elgato. Where you at? Definitely earn that. All right. Yeah, this should work. That is for you, Mini Taka. Dropping the horn on you. Thank you for the very generous $50 ramp for your daughter's wedding tomorrow and the week-long after parties, Joe. You are too kind. Thank you so very, very much. I appreciate you. It's very, very generous. Thank you. All right. Where was I? The response from AT&T was on the first day of hearing 14-15. The PayPal donor was in Rumble. Yeah, but that wasn't her, though. I don't think that's a PayPal. That's not a PayPal thing, is it? I'm so confused. Well, either way, I don't think Minnetonka is Worcestershire either. I don't think Minnetonka is Worcestershire. Am I confused? I think those are two different people. But you know what? Let me see. She's normally in locals. I don't know. I appreciate the love, genuinely. Thank you. Let me get back to work here because I got work to do. Additionally, so we first had this meeting that we document 4.5 hours in September 11th to September 12th. Additionally, on November 29, 2021, Wade's phone was pinging East Cobb Towers near his residence following a call from Miss Willis at 11:32 p.m. While the call continued, his phone left East Cobb area just after midnight, so he's on the phone with her for a half hour, and arrived at the geofence located on Dogwood address at 12:43 a.m. On November 30th, 2021. Don't worry, honey, I'm on my way. Oh, I'm on my way. I'm coming. Phone remained there till 4:55 a.m. Now, they said over and over, never spent the night there. And I am sure that they'll say, no, that's not the night. I left before sunrise. Findings and data presented in a PowerPoint presentation, according to CellHawk, PowerPoint screen recordings are deemed to be the best way to present in a transparent way the totality of data upon which the animated map feature was built. It allows for simultaneous viewing of timeline, route of travel, tower hits, tower information, source of the hit, call data text, lapse time, among other features. Furthermore, juxtaposed to communications or the absence thereof, additional conclusions may be drawn from the data. You can draw your own friggin' conclusions. No, I'm not charging you for 24 hours of work for this stream. I'm not charging any of you anything. Anyone who no. All right. And here's the certification of cell record analysis generated by CellHawk. I hereby certify the following reports are generated from the certified AT&T records utilizing CellHawk analytics. And were not manipulated, edited to reflect anything other than available generated reports from the analytics tool. And we have the Wade Willis interactions for 2021. Data report of all communications. That's Exhibit A. Exhibit B is titled Wade Willis Heat Map, which that's really a poorly worded, that's a poorly termed thing. No one wants to think about the Wade Willis heat map. That's like the worst imaginable name you can give to any exhibit. Heat map report reflecting the timing of interactions with the prevalence of calls made in the evening hours. And the PowerPoint presentation titled Wade Geolocation Highlights. Slides 11 to 44, initial search for Wade visits within the Dogwood geofence, conservative data search described in the attached affidavit revealing Wade's cell phone pinging off of one of the two towers closest to the Dogwood address for an extended period of time on 35 occasions. Then we have slides 5 through 7, which show that September 11th through 12th, deeper analysis described the attached affidavit in Mr. Wade's cell phone tracking from September 11th to 12th that he's leaving Dorville at approximately 10:15, traveling directly to and arriving within the geofence at 10:45, leaving the Dogwood address at 3:28, and then spending a half hour in transit and getting home at 4:05 and texting her 15 minutes later. Then we have November 3rd, deeper analysis describing attached affidavit Mr. Wade's cell phone tracking. November 30th, we have a phone call from Fani Willis, 11:32 p.m., which continues for 40 minutes. We have him leaving his house at 12:05. Outgoing call at 12:38 a.m. to Fani Willis. Directly to and arriving in the geofence at 12:43. He's like, I'm almost there, baby. I'm almost there at 12:38. He has an outgoing call saying, baby, I'm 5 minutes away. I'm on my way. I got the chicken wings. I got the sushi. We're going to have a good time tonight. Leaving Dogwood address at 4:55 a.m. on working very hard on emotion. Working way too hard on emotion. And there you go. All right. So that is what we have He looks terrible. You have to admit, even if you're the biggest Fani Willis supporter out there, this doesn't look good. Doesn't look good. Doesn't look like you were honest. Because we need to remind ourselves as to like exactly what these people said. What did he say? What did he say? Well, I want to go back to what he said. Let's check out some of his testimony here. This is what he said to Steve Siddell when he was on the stand.
The Hapeville condo prior.
Go back at normal speed. We'll do 1 1/4 because we can.
To say that no. Okay. And again, that was for privacy, according to your testimony. Privacy, yes, sir. Okay. Did you and Miss Willis go to the Hapeville condo prior to your relationship starting the beginning of 2022? Prior to having physical contact, prior to having intercourse, did we go to the Hapeville condo? Again, you keep going to intercourse. I'm trying not to, but fine. The answer to that, my question would be yes. Did you and Miss Willis go to the Hapeville condo prior to what I want to say November 1st of 2021? Yes. Okay. And the purpose for going to the Hapeville condo with Miss Willis prior to 2021 would have been what? Or prior to November 1 of 2021? Could have been any number of things, because at that time,
any number of things. Give us a list.
That's what I'm asking. So tell me. Yeah, could have been any number of things, because at that time, she had a friend living in that condo, Miss Yurdi.
Ooh, threesomes
In that condo.
Yurdi supposedly wasn't there when Fani was there. That's what Fani testified, that Yurdi was never there. And Yurdi testified the same thing. So I don't know what he's talking about here. This seems like complete BS.
Okay. Maybe it was my question was poorly worded. Let me try again. Your answer is yes. Prior to November 1st of 2021, you would have gone to the Hapeville condo and been there with Miss Willis, correct? Yes. And you would have been there, as you indicated, for many reasons, right? Yes. Can you give me just list a few of the reasons? Miss Yurdi resided there?
Nope. That's not a that's Fani Willis testified contrary to this, saying Yurdi was never there when she was living there.
Went to visit her?
Nope. Cannot be. That's contradictory to what Fani Willis testified to.
Maybe went to talk about a document that I received. You would go to the condo to talk about a document that you received? Absolutely. Okay, go ahead.
Absolutely, of course.
Absolutely. Any other reasons? None come to mind. None come to mind? No, sir. And would you say that was frequent? When I say frequent, do you think prior to November 1st of 2021, you were at the condo more than 10 times? No, sir.
No way. No way. No way more than 10 times. 35. 35!
Yes, sir. So if phone records were to reflect.
Oh, phone records. Now this should have been this to a seasoned attorney. This should have been a red flag. Like, wait a minute. Now we're talking about phone records. You should have been kind of thinking to yourself, why is he asking me about phone records? Why is he asking about that? That's a little disconcerting. I don't really like the idea of there being phone records.
So more than 10 times? No, sir. So it'd be less than 10 times? Yes, sir. So if phone records were to reflect that you were making phone calls from the same location as a condo before November 1st of 2021, and it was on multiple occasions, the phone records would be wrong? If phone records reflected that, yes, sir. They'd be wrong. They'd be wrong. Okay.
Very wrong phone records. Obviously, someone stole his phone, took it to Fani's house, dropped it off there for a few hours, and then drove it on back. That must be what happened, because he wasn't there. He wasn't there. Someone obviously at 12:30 in the morning decided to drive his phone over there while they were talking on the phone to her. Very obviously.
Where did you live during that time period? Same place I live now. Which is not in Hapeville, correct? It is not in Hapeville. It is north of Atlanta, the city of Atlanta, correct? It is. Okay. And any other reasons why you would be in the Hapeville area on multiple occasions prior to November 1st of 2021? Let's see. The Porsche Experience is there.
Oh, Porsche Experience. We checked that out already. 9 a.m. to 1 p.m. and 1 p.m. Nope, probably not that. Probably not that. Nope. I don't think so.
I'm sorry? The Porsche experience is there?
Okay, so that would have been one. Any other reason?
Yes, sir. The airport is there?
Airport in Hapeville.
Yes, sir. Delta Airlines is
Okay.
headquartered there.
So it's not the airport's there. It's Delta Airlines headquarters there. Whatever he's doing there, I don't know. They obviously were servicing him at 12:30 in the morning at the headquarters.
Let's see. Restaurants there?
Okay.
Oh, I'm sure lots of restaurants in that area are open at midnight. Plenty of restaurants. Everyone knows Atlanta is famous for its midnight dining. You want to know why he's asking this question? He's asking this question because he wants him to basically identify. Because this is what you do when you're questioning someone like this, especially if you're planning on ultimately catching them in their lies later on. One of the reasons he asked, I would think that Steve Sado asked this, is that you think to yourself, I'm going to be presenting evidence which is showing that this guy is full of crap. So I want him to lay out all the potential excuses. If I don't think that this guy is trustworthy, and I think that he is more than happy to lie under oath, because I think he's lying right now. So that means he'll make up whatever reasonably comes to mind. So one of the reasons you ask a question like this is because he could have said something that would have helped him, and that would have been difficult for Steve Sado to show to be untrue. And though that could have been, he could have said something like, I had a girlfriend living there by the name of, I don't know, Brenda Miller, who lives in that area. He could identify someone who he knows, or some guy who he hangs out with, who lives in the same area, and that could have presented some sort of deniability, where he could say, yeah, I was hanging out at that guy's house all the time. I used to go there. We'd, shoot some pool. We'd play some video games, whatever it is, that he could basically say, I would go there to hang out. When you throw out here, why would you be in that area? And he stupidly relies on the Porsche experience in Delta headquarters. He didn't come up with, oh yeah, I used to go there and hang out with a buddy all the time. And that now, if he were to try to introduce something like that, now that the cell phone records are refuting his testimony, for him to try to come up with something like that would seem utterly disingenuous, like it's just another lie on top of another lie on top of another lie. That's why you want to lock him into his story. This is one of the things I was talking about when I was covering the whole Disney thing, and how this investigation that the EEOC is doing into Disney is a healthy thing, because it just locks them into a position that's very difficult to then change if that position that they're going to take, whatever that position is, as to why it is that they sent out these crazy woke policies which violated the laws to their hiring practices, that whatever excuse they're giving, you want them to at least be locked in then and to that story, and then you could pound on that story. And if it's this story, then you pound on this story. But whatever their story is, you want to give them as little maneuverability as possible. And the way you do that is have them basically provide their explanation in front, in a context where they're going to be supposedly being as forthright as possible. So it's difficult to maneuver later on without looking like the utter liar that you are. So that's why Steve Sado is saying, give us all the reasons why you'd be down there. And now when he's limiting himself to these stupid things that would only happen during normal business hours, now you show phone records saying, well, okay, well, obviously you weren't at Porsche Experience at 1 o'clock in the morning. You weren't going to restaurants at 1 o'clock in the morning. What the hell were you doing there? Even if we can't show that he was in her house proper. There you go. It's good lawyering. This guy, Steve Sado, he's one of the best. As far as lawyers go that we've seen from Trump, he's really been up there. We've seen a lot of his attorneys. I really like his work a lot, Steve Sado. I've been very impressed by him.
If that's your recollection, that's fine. I'm not asking you to try to remember everything, but if that's
okay.
okay.
And the idea being, if there was someone he was going to there dozens of times who was a friend of his, he would have likely remembered that. You can't say, I went there 3 dozen times and hung out at this guy's house and we do pot together and I totally forgot about that. You know, he's remembering the one time he went to the Porsche experience. So that's what's happening. That's what's happening in that exchange. It's good lawyering. It's very good lawyering by Steve Sado.
Did you discuss your affidavit filed in connection with the response with Ms. Willis?
All right, so that's enough of this for now. That to give us a flavor for how it is that he got cornered here very well by Steve Sado, because Steve knew that he's going to later. He knew, and when this was happening is when they first were getting in the evidence. So he had an idea that phone records are going to be coming, and that's why he's asking him, give me a reason why phone records would show something else. Lock yourself into a position now. And the only thing he said is, I wasn't there, or I was at the Porsche experience, and I went there fewer than 10, or much less than 10 times. And now we have, okay, so now, and there's no other reason for you to be in the area at 1 o'clock in the morning. It's a great job. Really great job. So basically, Trump put a geo wall around Georgia. Yeah. Thank you so much, Leslie. I appreciate you. Thank you. He's going to make Fani pay for it. Yeah, well, they're both going to be paying for it. Why didn't they subpoena Fani's phone too to compare it to his? I don't think you need to subpoena. They may have. I don't know. Maybe it's taking longer for them to get their records. They likely did. They likely did subpoena her records. I would assume that they probably did. It's a good question you're asking. But I think his phone records showing that he's texting back and sending calls out to her number and back from her number. It's like, you think her phone records are going to be showing that she didn't get any of these texts? It's hard to imagine. So I don't think it's I think it's nice to what they would call have belt and suspenders, where you have both ways of covering it. But I don't think it's essential in this particular scenario, because it's hard to have phone records showing one way and then the other person's going to be like, I didn't get any of these texts. I don't know why his phone's showing that. That seems difficult to swallow. So anyhow, so that is what we have here from the proposed exhibit that Steve Sado wants to bring into the court to refute his testimony. Let's check our response here from Fani and the district attorney's office, which came in late Friday. You probably have not seen this yet. You may have. I don't know. It depends. I haven't seen everyone's coverage on this. But here we go. State's objection to this intrusion, this new proposed evidence from coming in here. All right. So come now, state of Georgia, by and through Fulton County District Attorney Fani T. Willis. Both objects to and moves the court to exclude defendant Donald John Trump's proposed supplemental exhibit 38, which has been improperly submitted to the court for consideration, violation of OCGA 24-7-701. And again, I want to point out, what she brings up here are fair points. They are fair points from a legal perspective that she's going to raise as to why it is that the court should not consider this. It's still, and I'll explain to you why, even though she may succeed in keeping this evidence out, which would be very annoying to those of us who want to watch her fat Fani get fried. She may, but the judge is still is in a really rough position if he's going to try and keep her in here. So comes now Fani Willis, both objects to and moves the court to exclude Donald John Trump's proposed supplemental exhibit 38, which has been improperly submitted to the court for consideration in violation of OCGA 24-7-701, United States Supreme Court ruling in Daubert versus Merrill Dow Pharmaceuticals 509 U.S. 579. Daubert is the standard that is used for determining when scientific evidence is considered admissible. You have to, the Daubert Supreme Court ruling is a very significant case in that it sets up standards that are minimum threshold standards to establish whether or not something can be deemed scientific evidence or not. And there's, I think, 5 things that you have to test to see whether or not Daubert has been met. It's called a Daubert standard, a Daubert test. So I didn't know there was more than one. So I have no idea. But Daubert whenever you see a Daubert objection, it's basically saying it's what you're trying to offer here is junk science. It's not accurate science. And when you have junk science, we do want to have that be inadmissible. And the reason you want to have that be inadmissible is because it's more likely to misinform than inform. So imagine someone comes in and says, yeah, I'm a scientist and I've done these studies that show that light rays make you grow 9 feet tall. And if someone was submitted to enough, it's like some jackass basically comes up with his own scientific research, which no one else can corroborate, confirm, or something like that, not accepted by any other scientist. And you have some crazy loony out there, but that might confuse the jury into thinking, oh, this is a reasonable explanation. So the Daubert standard is basically, the Daubert test is designed to basically keep that from coming in before a trier of fact and potentially making them less informed than more informed. That's what the Daubert test is all about. And they're going to claim that this science here that's being offered by this in this evidence does not meet the standard of Daubert. I meant getting her location data compared to his because she's saying it's bogus. Oh, well, let's look through the rest of this, and we'll see. We'll try to analyze that. Okay. Supplemental Exhibit 38 contains both telephone records that have not been admitted into evidence and an affidavit and other documents containing unqualified opinion evidence. Okay. For the reasons set forth below, court must exclude defendant Trump's inadmissible proposed supplemental exhibit 38 from consideration, or at a minimum also must consider the state's rebuttal evidence that demonstrates the unreliability of the unqualified opinion evidence improperly introduced. Trump's proposed supplemental exhibit 38 was improperly submitted in direct violation of the court's own standing case management order for criminal cases and should not be considered. While defendant Trump's proposed supplemental exhibit 38 cleverly avoids the use of the term expert, it's clear that defendant Trump's submission is an attempt to have the court improperly receive unqualified opinion evidence as written expert testimony. And this is a fair critique that they're trying to raise. You can only attest to facts that you personally observe. And when we're talking about these facts here that were personally observed, as opposed to opinion, the only one who can testify to opinion is someone who's qualified as an expert by the court. If you're not qualified as an expert, you're not allowed, you can only attest to facts, not to opinion. So when they're coming in here with their experts saying, I've looked through this and I've reached a conclusion that it's saying that he's at her house and that she went to her house. So now you didn't see him go to the house. You didn't even see these records being generated. You're looking at a report and taking these reports and coming into a conclusion that this means he's at her house. It sounds like you're offering an opinion. Now they avoid referring to him as an expert, and it's probably true that they intentionally avoided referring to him as an expert, even while they're listing off all his qualifications as to all the standards that he took and all his levels of expertise, and basically implying that the court should look at him as being an expert. And he's about to start giving his opinion on things. So you can understand that he is coming across like an expert, even though they artfully did avoid throughout the affidavit the use of the term expert. They're trying to pitch him as being a fact witness. These are the facts that I've seen. I see these records over here. I see these things being, I see these cell hawk results saying X, Y, Z. And they're trying to say that he's attesting to facts. But realistically, these are the sort of facts that an expert would attest to. Interpreting it is something you wouldn't just have some fifth grader come in here and say, yeah, I saw these records. You would want to have someone who's an expert at understanding what they're looking at, who's going to come in and attest to it. So they don't call him an expert, but they do go a long way towards trying to show how much licensing experience and how long he's been using it, how often he gets using it, and that this is the type of information that is used by all the experts in the industry. And this is probably what the district attorney's office is baking in all these things that they need to bake in to show the reliability of the evidence that they're putting forward. It does have the feel of expert testimony. So you can understand why it is that they're saying they don't call it expert, but they're treating him like he's an expert. And that's a fair critique. What we got here? If Big Fani gets cell phone data thrown out, how many defense attorneys are going to ask for retrial if the phone data helps convict their clients? So the question is why it would be thrown out. Because there's a lot of different bases to throw it out. If it's thrown, it's unlikely the court's going to throw it out by saying cell phone records are unreliable. Because clearly cell phone records are relied on all the time in so many different cases. And that's what's leading you to your question. You're like, what do you mean you're not going to listen to, you're not going to check out cell phone records here? And in so many convictions, we establish the location of a defendant based on their cell phone records. So you can't just start making new rules because we're dealing with the district attorney here. You're correct in that. The point being, though, if it's not thrown out because we say we never rely on cell phone records, but it's thrown out because cell phone records have to come via an expert, and this person has not yet been qualified as an expert, that's a reason to say, I can't look at this because the only way I know anything about this is because of testimony that's inadmissible. And if this guy had come forward on February 15th with proper notice beforehand for qualifications of an expert, I would have listened to him. And I would have admitted these cell phone records. But at this juncture, it's too late to do that. That's a basis to reject his evidence as basically not being timely offered without making a ruling that cell phone records as a general rule are inadmissible. And that's one way that the court could theoretically get around it. But even getting around it, you'll see by the time I wrap up, you'll see how it's almost impossible for the judge to just pretend that this never was offered. It's almost impossible for a number of reasons. The judge ignored Fani's first two good points since evident perjury has been proven from their own mouths. Oh, PayPal says, yes, sent to you. PayPal says it was sent to me. Doesn't make any sense. The heck is happening, PayPal? Whoa, there it is. Thank you. Now it came through. Thank you so much. Wow, you're too kind. What I'm seeing here is for tiny good logic. And she's not tiny, but she's the smallest of the good logics. It's hard for me to read the entire thing. Oh, here it is. Congratulations on your family's special day. Have a great day. Have fun spending this money on yourself because it's the only girl who's super precious to all. Love, Wuss, and family. Oh, you're so kind. Thank you so much. It was really very generous of you. Sending over $60. God bless you, Worcestershire. You're really too kind. Thank you. Thank you so much. Oh. All right. Where was I? This was about notice of delay of hearing solve. Oh, yeah, I agree with you. That would be a solve. I'm hoping that happens. That's what I'm hoping is what happens. But let's get into a little bit more about what their objections are. While they avoid the use of the term experts, clearly defend Trump's submissions and attempt to have the court improperly receive unqualified opinion evidence as written expert testimony. The court's own standing case management order for cases state as follows: experts, any party seeking to rely on expert testimony at trial or evidentiary hearing, must provide written notice to the opposing party. This notice must include a meaningful summary of the expert's testimony, as well as his or her qualifications to serve as an expert witness, and must be provided at least 7 days before any evidentiary hearing requiring expert testimony. Now, this, as far as the timing of this is not an evidentiary hearing which requires expert testimony. It's being offered, not being required. So in that sense, I don't know if this last sentence is relevant, but it does seem as if they probably have to provide a written notice to the opposing party and that they have to include a meaningful summary of the testimony, as well as the qualification, as well as Charles Middlestat's qualifications before they try to offer it. So these do seem like reasonable objections for the district attorney's office to be raising. Trump's proposed supplemental exhibit 38 violates this mandate of the court in 4 ways: no written notice to the state, no summary of purported expert testimony, no information related to qualifications, and no notice provided at least 7 days before the evidentiary hearing that begins on February 15, 2024. Again, they can say that they didn't have it until February 15th, which is true, based on if we believe this affidavit as being true. So they didn't have it, but the judge can say, well, you could have ordered it a month earlier, and you didn't. Okay, but we really wanted to use it to impeach him, and we didn't know what he was going to say, and there's way too much information to go through if we're going to go through his entire phone records. So at the conclusion of the portion of the hearing held on February 16th, counsel for defendant Trump stated, "We are in the process of, if the court will allow us, to obtain certain phone records, and we'd like to record the record kept open for the introduction of these phone records. We have them in draft informally. We do not have certification of them. And they would deal with, if you'll remember, I asked Mr. Wade about certain activity down in Hateville during that time period, and it deals with the specific time period we're talking about, February and March 2021 through November 1st. We would want to, if what we believe is based on our preliminary research is there, we'd like to reopen and introduce records and someone to explain what they mean." Meaning we want to really put this guy on the stand. That's what we want to do. We want to put him on the stand. Now, if you think about it, the next hearing return date is March 1st, which is next Friday. They filed these papers on Friday. So that would satisfy the week-long issue. It also may potentially satisfy these other issues, providing a written notice to the opposing party. You got your 7-day written notice, and include a meaningful summary of the expert's testimony. Well, they got that too. So imagine if we say now we're going to let him take the stand and get cross-examined. Would that not satisfy all the issues that are being raised here? I respectfully submit that it would. If you were Judge McAfee and you say, okay, you know what, let's put this guy on the stand. Bring your guy down here. We'll put him on the stand. Let him get cross-examined by the state. Put it, and then offer up this as evidence. And we can have a voir dire about his expertise, and if he satisfies the court that he meets all these yardsticks, I don't see why that would be a problem. So this is a reasonable objection today on February 25th, or when it was filed, February 24th. But we can remedy this on March 1st. At the conclusion of this portion of the hearing held on February 16th, counsel for it said this. And counsel for defendant Roman also stated, as soon as we got a hearing date and the state's response to what happened, when the state responded February 9th and admitted to relationship with the parameters on the timing, I sent subpoenas out in response to that. So that explains why they waited till February 9th. This is a good explanation. We waited till February 9th because that's when they admitted that there was a relationship, and they claimed that this relationship only was commencing in March or April of 2022. So we needed some sort of response from them. As soon as we got that, we're like, all right, let's get the phone records now. Let's go get it. That's a nice explanation. These DAs are very stupid. There's no reason for them to include this. The problem is Delta, AT&T, and those folks aren't super fast about all that. I know Delta, we were also waiting. I wanted to remind the court, waiting for those records to be submitted in camera. And AT&T actually emailed me these phone records yesterday morning on the way to court. Okay. Representations made by counsel for Trump and Roman make very clear to the court several relevant facts. One, defense counsel issued subpoenas to fellow phone records at issue on about February 9, 2024. Okay. Counsel had the subpoena telephone records in the possession at least as early as February 15th. Okay. Defense counsel always intended to attempt to introduce both the telephone records and the expert witness to explain what they mean. In spite of this, Trump made no effort to comply with the court's own standing case management order for criminal cases. How not? By waiting until the 23rd to enter them? I mean, to have them translated to figure it out? That doesn't make any sense. Trump provided no written notice to the state in advance of the hearing. They didn't have it in advance of the hearing. Provide no summary of the testimony and provide no information related to qualification to serve as an expert witness. Again, all this stuff could be remedied by just having him take the stand on the first. The court's standing case management order for criminal cases was specifically intended to prevent parties from ambushing opposing counsel reported expert evidence, without allowing opposing counsel a meaningful opportunity to review the evidence, review the purported expert's report and qualifications, and obtain its own expert rebuttal. Well, now you have it. What's the problem now? What is the problem? Coming on March 1st. Court cannot now allow Trump to bypass this protected procedure when in other cases it has excluded expert evidence for parties' failure to follow the standing case management order in criminal cases. Like when? All parties coming before this court must be treated equally. Indeed, treating like cases alike promotes a system of equal treatment under the law rather than one built on arbitrary discretion. Yeah, well, this is a kind of weird case where we had all this stuff with Bradley going on there, and he gave broad discretion there, which is why this hearing's been dragged out for weeks. So I do think that the court probably has very broad discretion in how he handles this application. He probably has very broad discretion. And whatever he decides, probably whether he decides in favor of Trump or against Trump on admitting this evidence, he's probably going to win. In other words, he probably will not be overturned on appeal. So I think that McAfee has probably very broad discretion here on bringing this evidence in or what steps he wants to take to remedy any notice issues. That if the state were to appeal a decision against them or Trump were to appeal a decision against him, that the appealing party would likely lose and the judge's ruling would likely be deemed correct, based on what we've seen so far. But let's get to the further points here, because maybe there are other points which are stronger. Didn't really get to the Daubert point yet. Trump's proposed supplemental Exhibit 38 improperly submitted in direct violation of 24-701 and Daubert. Effective July 1st, 2022, the General Assembly revised longstanding Georgia evidence rules regarding lay and expert witnesses' opinion testimony by applying the provisions of OCGA 24-701 to criminal matters, substantially consistent with the standards set forth by the U.S. Supreme Court in Daubert. All right, let's start getting into Daubert here a little bit. Let's start looking at some Daubert. Give me some Daubert. Okay. Daubert as applied by Georgia. The provisions shall apply in all proceedings with limited exceptions that do not apply here. Okay. Trump now seeks to submit supplemental Exhibit 38, which contains, among other things, an affidavit of Middlestat that consists of opinions based on scientific, technical, or other specialized knowledge within the scope of OCGA 24-7-702. This type of opinion testimony is specifically prohibited if a witness has not been qualified as an expert, which sounds logical. Again, so get him on the stand and then see whether or not he can get qualified as an expert. No applicable exceptions exist under Georgia law. Prior to providing expert opinion testimony, the court must make each of the following findings based on the evidence in the record. And here's the argument that we can anticipate that Sado is going to make is, I told the court that we had these phone records. I told him that we plan on introducing it. We need to go through them, that we first got them now, and I plan on introducing it if still possible. And I'd like to reserve that opportunity. So it's not like the entire record here was closed, because I made clear that we don't want the record closed. And it's not like the court said the record was closed. If anything, the record still remained open as to what we're going to do with Bradley, and things were still likely to come in. So Sado has a pretty strong argument to make here. And I'll tell you this, the judge has been relatively fair. He's been relatively fair in the way he's handled this motion, this entire motion for the last 6 weeks. Even granting a hearing, this is something I want to point out to you. A lot of judges would not have granted this hearing. A lot of them who would have been, let's say, strongly left-leaning would have been like, this sounds like just salacious gossip type of thing, and I don't see enough here, and this is a fine explanation from a trusted officer of the court and Fani Willis that the relationship was non-existent then, and I'm satisfied that this avoids any appearance of impropriety. That's what a leftist judge would have said. That's what Judge Engoron. I'm concerned that Judge Engoron would have said something like that from what we've seen. So this judge has not seemed to be tilting, even though he has worked for Fani Willis, even though supposedly he contributed to her $150 to her campaign, which is not a great deal of money, but it's some money, showing that he has an affinity to her after working for her. But he does seem to be interested in at least appearing like he's handling this properly. And when I was looking at the different rulings he was making, they seemed reasonable. Would I have agreed with all of his rulings? No, but I'm probably never going to see a judge I'm going to agree with all of his rulings. I'm just saying that when we're looking for fairness, on a scale of 1 to 10, from what we've seen so far, you have to give him at least a 7, if not an 8, 8.5. He's been relatively fair. So, and if he's going to continue being fair here, well, in that case, there's a way to remedy all these things that the DA is complaining about. So he says they say there are no applicable exceptions except under Georgia law. Prior to the providing expert opinion testimony, the court must make each of the following findings based on the evidence of record. The expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or determine a fact and issue. Okay, well, there's a fact and issue here as to when the relationship began. And he's providing evidence as to when they're meeting and unusual hours that they're meeting. Testimony is based upon sufficient facts or data. And cell phone information seems to be pretty significant. Testimony is product of reliable principles and methods. Well, they seem fairly reliable. We use them in many trials. And the expert has reliably applied the principles and methods to the facts of the case. The party advancing expert testimony has been the burden of establishing admissibility under 24-7702B. Okay, here none of the required findings have been made by the court. That's true, not yet, but it is easily remediated. And no timely, competent evidence that complies with the court's standing case management order in case exists in the record that would establish even one of these factors as our law requires. Okay, so for him to do it without having a hearing, I agree with the DA that if we don't bring this guy on the stand, there's serious issues as far as following standard court procedure. Indeed, Trump has provided no competent evidence whatsoever that would establish that Middlestad is in fact an expert in anything. That's true. That is true. There is no evidence that he knows other than his affidavit. That's not considered evidence of his being competent. I wouldn't say no evidence, but I would say probably insufficient evidence, at least what we have so far, but the record's still open. Moreover, the telephone records that issue themselves, which form the basis of Middlestad's purported expert testimony, are not properly in evidence. Okay. No one has authenticated telephone records at issue, and the certificate of authenticity of domestic records pursuant to federal rules of evidence, 902.11 and 13, is insufficient. 11 states that are party intending to offer business records into evidence under that code section shall make both the records and the declaration available for inspection sufficiently in advance of their offer into evidence to provide an adverse party with a fair opportunity to challenge such record and declaration. You have it now. You got plenty of time now. There's no hearing continuance until March 1st. You got a whole week. Contemporaneously providing the certificate of authenticity and the telephone records to the state after the close of evidence. It's not after the close of evidence. Why are you saying it's after the close of evidence? This, to me, with that they're putting in italics, seems to be an inaccurate statement. We don't even know if Bradley's going to be testifying still. So there's certainly we're not at the close of evidence. And you admitted earlier here that they preserved their right to submit more evidence, specifically about telephone records. This is why I'm saying I wonder about the competence of some of these lawyers who are working for the state. You need to actually remind the court that you're aware of the fact that they said they're going to bring in these phone records. That's smart lawyering there. I think that sometimes I look at them like, you guys are idiots. You're idiots. Let the other side claim that it was that they tried keeping the record open. If the judge had said no, we're done, and the record is now closed, other than what's going to happen with Bradley, you could throw that in there. That would be powerfully helpful to you. That's not what happened. And since that's not what happened, why are you reminding the court that the record is still open and that the defendant said we may want to introduce phone records? Is there anything on the record saying that you object to the phone records? Why didn't you object to the phone records then? Why didn't you say anything about it then? Now you're first raising the phone records issue? What did you think was going to happen with the phone records? That's what I'm saying. I feel like they're almost like it's like they're like middle tier, low end tier, like night school law students who are trying this case for the state. It should give you a lot of heart if you're hoping for Trump to succeed in any potential litigation that will go forward. The idea that these are the ones who are trying to throw the former president in the clinker should make you take a lot of heart, because these guys make mistakes just virtually. They can't stop tripping over their own feet. They can't stop tripping over their own feet. It's just like they're like, and another point we want to make to the kerplunk. Like, it's just what happened? How did you fall on your face? What happened? Didn't you see that you were like walking into a wall and there's like this big tripping thing, which actually says on it, tripping thing, don't trip on it. They get up and dust themselves off, and 10 minutes later, they walk 3 steps later and make the mistake of trying to chew gum at the same time, and then just like slip backwards, like, whoa, splat. I don't understand. I've never seen I'm sorry, they're terrible. They're terrible at this. So bad, splat. It's like I think that this district attorney's office, it's like literally they should have like the Batman Kablawi pop up over them all the time. Kapow! It's like I feel like I'm watching a 1960s like television show where Batman in his stupid purple cape and underwear boy wonder is, you know, are taking like a bench and swinging it at a bunch of 60-year-old 70-year-old criminals wearing cat ears. This is so bad. What is happening? These are the people who think they're going to convict the former president of the United States. Batman, Kaplowy, Kersplat. That's what I'm watching here. That's what it feels like as an attorney watching. Like, this is like, that would never this would never happen in real life, but yet it is. Yet it is after the close of evidence. After the close, it's a nice quote to have. It's not sufficient advance notice to provide the state with fair opportunity. Quoting Gregory v. State. Well, this is not after the close of evidence. So how the heck is that relevant? Kaplowy. Kapow. Zowie. Zowie. I don't know what I'm seeing here. It's terrible. Terrible. Oh my God. Oh my God. Whew. Court should not excuse defendant Trump's failure to comply with OCGA 24-9-902-11 when it's clear from the record that Trump subpoenaed records as early as February 9, 2024 and had both the records declarations of possession by February 15, 2024. Well, they weren't interpreted yet. So what are you going to do with them? We're just going to submit something that we just got 30 seconds ago and say, this is what we got? It's so stupid. It's like, okay, thank you. Rather than providing notice to stay at that time, they did. They told you we have phone records. He never provided notice and instead is now attempting to ambush the state with these unauthenticated records only 5 business days in advance of scheduled closing arguments to deprive the state an opportunity to rebut. I don't know that we're done with evidence. We still don't know if Bradley's coming in here. It's supposed to have the whole in-camera thing that we're talking about. What are you talking about? What are you talking about? When was the record closed? Court should not now reopen the evidence, disregard its own standing order, and allow defendant Trump the opportunity. Look, maybe it was closed behind closed doors and they never told us about it. It's possible. It's possible. There's no record. Nothing on the record, on the publicly available record, says that the record for evidence be submitted is closed. And it doesn't seem like, I want to just look at this. Did they say reopen? Do they think it's closed? Let me see this. Did they say reopen? Doesn't seem like they think it's closed. And they say he's available to testify at the court's convenience. I don't know what the heck they're talking about here. I think that Sado has displayed sufficient competence that if there was a need to reopen the record, I feel confident he would have raised it. I think the state's making this up. If the court determines that Trump's admissible untimely, proposed supplemental exhibit 38 can be considered, the court must also consider the state's rebuttal evidence. Oh, okay. Let's hear rebuttal evidence. Notwithstanding the inadmissibility of defendant Trump's proposed supplemental exhibit 38 under the court's standing case management order, pursuant to the court's own evidentiary ruling against the state at the hearing, the phone records are at issue are inadmissible. We got that. When the state attempted to impeach the testimony of defense witness Terrence Bradley concerning the circumstances surrounding his departure from Wade, Bradley Campbell firm, the court ruled the state could not introduce extrinsic evidence contradictory to Bradley's testimony for the purpose of impeachment. Lord. Okay. Because Bradley is not the person that they're seeking to have removed. All right. Under Rule 608, I don't see how this is well beyond the core facts at issue. Core facts at issue. That's the point. It's like they include quotes which are showing you that the argument that you're making now is moronic. Here, you want to know why we're making this moronic evidence? Here's another Zowie moment. Zowie! Like, what's happening? I don't understand. They write here, I don't see how this isn't well beyond the core facts at issue. So what are the core facts at issue? Well, when the relationship started, as opposed to core facts at issue as to why was Bradley removed from WBC? You don't see a distinction here, Abby Cross? You don't see a distinction here, Fani Willis, between extrinsic evidence that shows whether or not Terrence Bradley left the firm because of essay allegations or because of some financial issue, that the court says that's really extrinsic evidence on a very non-core issue, as opposed to extrinsic evidence that shows that they were having a relationship before 6 months earlier than when they admitted to having a relationship. It's like, and you don't realize that when you're saying that this sentence here shows why you're an idiot. I don't see how this isn't well beyond core facts of this issue. I mean, confronted him, I think he answered this saw fit and argument can be made as a result, but to go down a whole mini trial on whether he did or did not do this, circumstances leaving firm, I don't see how that gets past 608. Yeah. I don't see how that gets past 608. As opposed to extrinsic evidence, which goes directly to the heart of what this entire freaking hearing was about. Here, defendant Trump attempts to do the exact same thing. No, it issues extrinsic evidence purportedly contradicting special prosecutor Nathan Wade's testimony for the purpose of impeachment. If the court did not allow the state to impeach the extrinsic evidence, it cannot allow defendant Trump attempt to do the same thing. All parties coming before his court must be treated equally. This is a court thing! Idiot! Idiot! I think it's like, how do they write this with a straight face? How do they write this? How stupid are you? Even in spite of this evidentiary deficiencies, which there are none, the court determines that it can still consider defendant Trump's proposed supplemental exhibit 38. The phone records simply do not prove anything relevant. You got nothing. It's not relevant at all. Like where he was at, the fact that he was at Fani, not relevant that he's there at 3 a.m. Why is that relevant? Records do nothing more than demonstrate Special Prosecutor Wade's telephone. His telephone was located somewhere within a densely populated multiple-mile radius where various residences, restaurants, bars, nightclubs, and other businesses are located. But he didn't mention any of them. All he mentioned was the Porsche experience. The records do not prove in any way the content of the communications between Special Prosecutor Wade and District Attorney Willis, other than the fact that there's 12,000 of them. This is such a dog ate my homer. So 12,000. That's not crazy high. They did not prove that Special Prosecutor Wade was ever at a particular location or address. No, of course not. They did not prove that Special Prosecutor Wade and District Attorney Willis were ever in the same place during any of the times listed in the supplemental exhibit 38. In fact, on multiple relevant dates and times, evidence clearly demonstrates that Willis was elsewhere, including the work in the Fulton County District Attorney's Office and visiting 3 crime scenes where a mass murder motivated by race and gender bias is taking place. What? Let me see your Exhibit C here. Where's your Exhibit C? Is this Exhibit C? I don't know what the heck they're talking about. This is Exhibit C? Is this Exhibit C? Let's go. Let me see if I can find Exhibit C faster. That's B. Where's Exhibit C? What are you talking about? Exhibit C. That is Exhibit C. Yeah, there's a lot of evidence here. I don't know what the heck this is showing. They redacted everything. I don't know what the heck this Exhibit C is showing me. Do you see anything here? We're talking about September 11th and 12th or November 29th, 30. Where do you see this? They're showing dates November 17th. What the hell are you talking about? Here's June 30th. I don't know what they think they're showing here. Powerful stuff. Powerful stuff. April 12th. What the heck are they talking about? That's Exhibit C. I think they're out of their minds. I think they're literally out of their minds. I don't know. Something is not adding up to me. They are so desperate. They are so afraid. They are so afraid. So I guess Visiting the 3 crime scenes where a mass murder motivated by race and gender bias had taken place. I don't know. I have no idea what mass murder they're talking about. Countless emails showing district attorney office at DA's office on dates that had nothing to do with the dates in question. This is insanity. This is crazy. What am I missing here? I'm gonna pause. Let me pause and check on you folks. Does the fact that phone records are for impeachment purpose nullify the notice requirement? Arguably could. Theoretically. I don't know enough about Georgia civil procedure to tell you whether or not it would. So, or it could be criminal procedure, probably. I don't know about Georgia legal procedure to tell you whether or not impeachment. I could hear an argument that it would, because it's impeachment. I think it's a great question, Ed. That was the first thought I had, but I don't know that's the case, which is why I didn't introduce it. That's a great question. And even so, like I said, this is easily remediated. And since it's impeachment, we're going to tend to be more forgiving on lateness when it comes to impeachment. You're correct in that for sure. So I'm not saying it when I say for sure, I'm not saying it does fix it. I'm saying you're for sure thinking along the correct lines that it's more likely to be accepted by the court because it's for impeachment purposes. That I would say it certainly is more likely. That doesn't mean it certainly will be accepted because it's coming as impeachment. I hope I was sufficiently clear on that. Trump and co-defendants will ask for delay Monday to solve all issues. Monday, Fani motions will be quashed by. I think that you're likely true. I think that that's likely to happen. I really hope that happens. Because I got to tell you, the one bummer for this whole thing for me, the one bummer is that he gave this March 1st not just March 1st, which is next Friday, which I'm making a massive party next weekend starting Friday evening at like 5:30. He sets up his freaking resume the trial at 1 p.m. on Friday. I'm like, really? That's when it is. I gotta get 4 hours. We're gonna have Lady Lawgic being like, "Where the heck are you? I need you to move chairs and do all this other stuff." And I'm gonna have this massive hearing concluding on March 1st. I was like, "You gotta be kidding me! How can that possibly be? Why would you pick? That's like the worst possible imaginable time." He didn't even pick Friday morning. No. This is gonna be Friday afternoon. Let's just let's make sure that Joe has zero time here. So I know he wasn't probably thinking about my schedule. Chances are very small that he was considering my schedule, but I'm just going to say personally for my schedule, it sucks. I hope you're correct that they push it back to Monday. And it definitely could happen. There are a lot of reasons for this to get pushed back. Love to see that happen. For obvious reasons. But so not the least, but I do plan on streaming on Friday afternoon. If it is Friday afternoon, I do plan on streaming it. I'm going till 5 o'clock. So I'll go from 1 to 5 o'clock on Friday, if in fact it happens then. So please make sure you're here. But who knows? This might be something that happens. I think everything is so fluid. I think we're going to see a lot more evidence be coming in. There's going to be a lot more back and forth here. Sado is going to respond to this. There's going to be this is just we're heating up. We are far from being done with this Fani exercise. No DI diggers in the tunnels. Diggers in the tunnels. They disappear. Yes. Oh, no DEI. Definitely. No questions asked. Could Fani also subpoena those phone records? Yeah, of course you can. Wade's law school ranked 171st. Fani's is 35th. Oh, you checked it out? It's terrible. Terrible work. Joe, that's all really cute, but you don't understand that Fani's not on trial here. White supremacy is on trial. Do not question or examine Fani. She's the district attorney. How dare you? Fair enough, Duncan. Fair enough. I'm simply saying, take heart in the fact that so far, McAfee has been reasonable. He really has been reasonable in the way he's approached this. Far more so than what many of us anticipated. Far more so. So let's hope that he keeps on being reasonable. Ray Runk says Fani can't see your evidence proves the phone data. Fani, I don't know what you mean by that. I'm sure what you mean by that, Ray. They now request Google, Apple, and phone itself. Could be. I don't know about that. I don't know about that. All right. I want to start clearing this off here so I don't get confused later on. Make sure I didn't miss anything over here because that was definitely possible while I was reading. No, we're good. I miss Chugi shows. I'm more fried than Fanny. I've taken some THC. Nice. Chugi on THC. Let me make sure I'm good over here. Worcestershire says, Joe Neiman, I don't know my PayPal name, but sign from Wiss and family. I saw it. Got it. Thank you. Thank you so very much. You're awesome, Wiss. Okay. Moving along. We're almost done. There's only one page left here before we get to our exhibits. All right. So now let's hear their dog ate my homework excuse. Trump's proposed supplemental exhibit 38, which is clearly inadmissible. Little evidentiary value, was not filed in good faith, and simply another attempt to garner media attention. The state submits the defendant's proposed supplemental exhibit 38 was not filed in good faith, but instead nothing more than another attempt to garner salacious headlines in the media. See, we even have a New York Post article. Some of the headlines, including the attached, were patently false, and many others were misleading. Roughly simultaneously with the filing, counsel for Trump immediately provided unredacted cell phone records, which contained personal identifying information belonging to Special Prosecutor Wayne and District Attorney Willis to members of the media. See Exhibit E. Oh, we will see Exhibit E. Portions of the Trump's proposed supplemental exhibit 38 include cell phone records with personal identifying information, which then quickly distributed on social media. See F. Oh, we're going to see F also. Lots of F. Trump's proposed supplemental exhibit 38 includes attempt to introduce evidence by affidavit, even though defendant Trump insisted that the state was disallowed from doing so and compelled Special Prosecutor Wade to testify so they could be cross-examined. Yeah, okay, that's very different. He's the key figure here. Trump's proposed supplemental 38 fails to comply with court standing order and evidentiary rules regarding notice qualification of expert witnesses. Moreover, the state questions whether Trump legally obtained cell site location information. Oh, he broke the law. Generally only obtainable after finding the probable cause and issuance of a search warrant. Maybe it became attainable after Wade put in his affidavit. What do you think about that? Maybe that's why I had to wait till February 9th. For all of these reasons, clear defense Trump's proposed Exhibit 38 is inadmissible. I think they had a typo here. They don't mean to say it's inadmissible. It's inadmissible, was not filed in good faith, should not be considered by the court. For the reasons set forth below, court must exclude Trump's inadmissible post supplemental 38 from consideration. All right, let's check out Exhibits E and F. We all want to see that, right? Let's check out E and F. The stuff they don't want us to see, but they put here because this is like, the cat burglars are here. The cat burglars with their lion skin jackets, with those striped jackets that they have, the tawny colored black striped jackets and the cat ears that these 70-year-old crooks are wearing. Oh, here you go. Nathan Wade's phone pinged at Fanny's Willis home 35 times before they claim affair begins. Whoops. On 35 occasions, Wade was in the vicinity of a condo Willis, subleasing from a friend in Hateful, Georgia for an extended period of time between April 1 and November 30th. Many of those visits before Wade was hired by Willis to be special prosecutor. Appeared contradict court testimony last week. Yeah, it seems pretty salacious when your freaking special prosecutor is busted for committing perjury on the stand. That sounds pretty freaking salacious to me. Duo told the court that they didn't strike up a romantic relationship until the spring of 2022 and broke up around a year later. However, in the lead up to Willis hiring Wade and also the month after he signed his first contract with his office, he appeared to visit condo twice in the middle of the night, according to Middlestad, who analyzed mountains of cell phone and geolocation data from Wade's number. What else you got here? Sado saying, I inadvertently sent the unredacted cell phone records to Bill Rankin this morning. Whoops. When I realized the error, I immediately contacted him to avoid him explicitly not disclose to them to anyone else, not to publish the cell phone numbers. See, this is Sado showing good faith. He's like, whoops, really sorry about that. And I told him not to publish any of it. And he said he understood when not publish cell phone numbers or addresses, which he didn't. So this is Sado actually showing that he's a man, and they're trying to punish him for that because God, they hate men. Heat map of Fani Willis calls and texts with Nathan Wade in 2021. Both testified under oath there was no relationship, and here's the little freaking heat map. What an amazing heat map. This is what they should. This is so stupid. This is so stupid. Like, you literally just made this more accessible to more people. They're so dumb. They're so dumb. This is how I found the heat map. I found the heat map because they filed these papers. This is Streisand effect because they're idiots. They're idiots. Maybe they're like the Penguins henchmen who like all have to walk around in suits and fight Batman while wearing suits that are basically cuffed around the ankles as they sort of like, and they have to quack every time they punch. Quack, 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 ha, quack, quack, ha, ha. And he's just back there with his umbrella, with his little get him, get him, get him, get him, get him. They're so stupid. They're so stupid. My God. This is so incompetent. This district attorney's office is so bad. It's so bad. Oh my God. It's just, they're hilarious. All right. So there you go. There you go. Who knew this would take an hour and 40 minutes? Let's say she's successful getting thrown out. She still can't put the crap back in the bowl. Yeah, that's for sure. That's what I wanted to get. I'm so glad you brought this up, Techfell. If you're, and this is another reason that these are idiots. These are idiots. When they talk about this, they're so stupid. Let me just show you something. You have to ask yourself this. You're Judge McAfee. You're sitting here trying to figure out whether or not there's a public appearance of impropriety. So now this is out there, right? This is out there. And you idiots just help make this more accessible. This little graph here, which shows heavy concentration after hours 7 days a week. So even if he keeps it out, you just help make it that much more public. Do you think that there's not a public appearance of impropriety when they see that for the year leading up to this, to his retention, that there's heavy concentration of after hours contact 7 days a week? Are you stupid? Do you not realize that even if Judge McAfee found a way to keep this out, said, they're right, I'm giving it, they're right, it's not admissible, the evidence is closed, whatever, tell me how there's not a public appearance of impropriety at this point. You just use your Streisand effect to make it tougher for the judge to find in your favor. That's how stupid you are. That's what I'm saying, is this is so dumb. This is so dumb. If anything, they should have brought an application to have it sealed. Say this should be sealed. But no. We're going to publicize it even more. It's like, you're so bad at this. How can you be so bad at this? God, it's like this office being run by children. They don't think like, okay, so now what position is McAfee in? Imagine you're McAfee now. You imagine your McAfee is going to come to how is he going to come to a conclusion now? And with a straight face that says, they don't need to be removed. There's no appearance of impropriety here. I can't find any appearance of impropriety. Like, he would sound like a joke now. He sounds like an idiot if he says there's no appearance of impropriety. Not just that everything here is kosher. Everything is fine. Everything is totally above board. But that there's no reason for the public. I can't imagine that the public thinks that there's impropriety that led to this prosecution here. Really? Really? He's supposed to say that with a straight face now. How did you not make it impossible for him to say that with a straight face? Even if this is held out. As Techfall's pointing out, you can't shove this back in this. The genie's out of the bottle. And the BS has left the bull's rectum. That's just That's just reality. Try shoving that back in. No one wants to do that. No one's saying, I did that. I shoved it back in there. No one's doing that. Defense claims Wade Willis met at certain times, September 21, And also November 2021, to prove Fani did not have time to meet at those times. She submitted calendars for April, May, June. Yes, I know. That's my point. They come up with totally different dates. You know how we know they couldn't have met on September 12th at this time? Because she had a meeting on October 7th. Okay. Calendars for April, May, and June. It's so dumb. I mean, it's like, I was like, maybe I'm missing something here. They can't be this stupid, but I think perhaps they can be. Perhaps they can be, because we've seen so much incompetence from this office. It's just an astonishing level of incompetence. Next thing you know, Fani will become part of the Me Too and claim it was all nice. He was beating me. Little Miss says, wait, was this Fanny's ovulation? Could be. That's not a bad guess. What do white hats, black hats think are the police baseband outages? What? White hats, black hats think of the police baseband out? I don't know what this means. Dude, what are you on? Wait, maybe just explain the next one. Is Infraguard down everywhere? I don't know what Infraguard is. What are you asking me, NYGHCF? I don't know what you're asking. I don't know what's happening here. The Fulton County District Attorney's Office take over your account. Is that is that what's going on here? Is that what's going on? I don't know what you're asking me. Close sidebar in Adobe. Joe's next to search. Oh, is that what I'm supposed to do? Close the sidebar? Yeah, I don't know how to do that. Do this? I did. I closed it. See, I got it closed. Doesn't look any better. Doesn't look any better. I can aspire to one day have the sort of passion in my work which allows me to work the long, hard hours Wade was working the early hours of the mornings at Fanny's home, all work related. And let me tell you something. If this was something, if the nights here were, let's say, the day before is the grand jury, there could be times, once in a rare while, where there would be like literally burning the midnight oil. I can understand that you're working together with them, but A, it wouldn't be in her house. It would be in the office. It would not be in her house. Unlikely would be in her house. Very unlikely. And B, it wasn't happening in September, 2 months before he's hired, or even a month into his investigation. Bear in mind that, you know, they don't have the special grand jury doesn't meet for, there's no special grand jury at this point. The first month. So, yeah, it could happen, but they'll be very, very, very rare. No one's working 12:30 in the morning, 1 o'clock in the morning, 2 o'clock in the morning, unless there's like literally like, okay, we have trial tomorrow, or, you know, in 2 days, and we have a ton of things to cover. What is CNN opinion on this evidence? I don't know. I don't worry about it. I had to say my last chat via Rumble, YouTube is gay. That is true. That is definitely true. True is saying, if she doesn't get removed, I'll cheer you up by digging a tunnel into a big chamber that is big enough for us to have our potluck. Sweet. Sweet. THC is strong and Chugi tonight. The THC is strong. Strong. All right. Whew. I think I'm going to wrap. I think I'm going to land my plane here. I was going to do the whole humanities and divine punishment thing, but I think it's time for me to start wrapping up. It's feeling bad for me. It's already 2:20 in the morning. I'm feeling bad for Lady Lawgic, who's got. We have a big day tomorrow. My daughter's getting married tomorrow, so it's kind of a big day. I guess later today. Yeah, she's getting married like in 14 hours or so. So. She does need her beauty sleep. I'm gonna let her crash now. And I'm gonna thank you all for joining me. I'm gonna probably end up covering the divine punishment thing on Locals sometime this week. That's probably what's gonna happen. I will not be streaming tomorrow because of the wedding. I do plan probably on doing a locals at some point. And you need to follow me on locals, which is goodlogic.locals.com, in order to know when I'm going to be streaming next. If you're here, please like and subscribe. I see there's 2,300 of you here, and there's another 500 in Rumble. This is Fani stuff. This is where I build my base. And you're never going to find me again if you don't hit like and subscribe. If you can share, all the better. All the better. They were clapping the midnight cheese. No one wants to picture that. No one wants to picture that. Nobody wants to picture that. Thank you so much, Malcolm. With all that, I thank you so much for joining me. I am landing my plane relatively quickly over here. I thank you so much for joining me. I will be back, God willing, on Monday, but I'm not sure about that. It depends on the whole after week parties. And Debbie, hitting you for dropping 5 Good Logic memberships. You are awesome. Thank you. Anyone who's not yet subscribed, hit it. And thank you so much, Adrian. Congratulations, you and a happy couple. You're awesome. Have a great night. Thank you all so much. Remember, no matter how rough it is without me, and I know that without me sometimes life can feel a little rough, but I will be back soon. In the interim, stay happy, eat some bugs, and as always, Godspeed.